Welcome to Steve and Tamara Explain Corp's Law, the podcast where two entirely self-appointed experts pretend to know more than they actually know about companies, directors, shareholders, and the occasional legal catastrophe.
This is the place where we take the cases, legislation, and big corporate theory ideas you're meant to understand, and then immediately make them sound much less serious.
So grab a coffee, open your textbook, and let's get into today's episode of Steve and Tamara Explain Corp's Law. Hi, I'm Dr. Steve Carabas. I'm an associate professor at Monash Law School.
And I'm Dr. Tamara Wilkinson, a lecturer at Monash Law School.
Welcome to Steve and Tamara Explain Corp's
Law.
Law.
Corp's Law.
That was perfect.
It was perfect.
Yeah, we can go with that.
Yeah.
Yeah, all right.
Yeah.
Because, things aren't always perfect.
That's true. And we're here to have fun.
Fun. That's right.
Fun with Corp's Law.
Yes. Yeah. You can have fun with Corp's Law.
You absolutely can.
And today we're going to be speaking about some really fun stuff. Shareholders and rankings versus creditors.
The reason I wanted to talk about this is because I've just finished updating the Laws of Australia Insolvency title, which was a ball of fun.
Congratulations.
Thank you.
Yeah.
And one of the cases that kept coming up was this Sons of Gwalia and Margaretic case.
Yeah.
And I was like, this name is coming up all the time. It's clearly a really important case. I remember vaguely learning about it in Corp's Law back in the day, but I don't know what it's actually about.
It's an interesting one for us because it kind of was huge at a particular time. And then as we're going to talk about, there were some follow-on ramifications that kind of have meant that it's not studied as much anymore.
Yeah.
But it's still a significant case because it tells us about how corporation law evolves, the role of courts versus parliament in these kind of matters, as well as looking at the corporations law itself.
Yeah.
Yeah. So I've got some questions
You've got
here.
the questions,
yes, that I wrote myself.
Definitely weren't written by me last night.
No, not at all, not at all. We know that shareholders and creditors do different things. They hold different positions in the corporation. Can you outline some of these differences and, what are the different kind of rights that shareholders and creditors have?
Yeah.
It's a big topic.
For our audience, all one of you out there. Hi, Mum.
My mum won't watch.
Fair, to be honest.
Unless we translate, we have subtitles in Greek.
Elenica.
Yes.
Steve was talking about this first question, and he was like, that could be the topic of the entire podcast. How are you going to answer this
We
briefly?
could probably do an entire series
just on that question.
Right? Because it's really looking at who is involved in the corporation, who do we need to consider when we're looking at corporate activity, what different actors, how do the laws regulate them, give them rights, protect them.
Yeah.
So it's a really huge topic, and we're going to cover it in about a couple of minutes here.
It's the brief explanation.
Yes.
So, very basically speaking, the shareholders own the company. As we know, they hold the shares. They make up essentially the company. They're the owners.
So the traditional narrative is that the conventional current narrative in Anglo-American common law jurisdictions is that the shareholders are the owners of the company.
Yeah.
But that is, we should say, debated.
Yeah. Yeah. I mean, you would know more about that than I would. I very technical investment lawyer. I'm like, shareholders own the company. Until someone tells me differently, that's the law. And then we have the creditors who, of course, are owed debts by the company. So, maybe suppliers, maybe employees, contractors, things like that. And so they're in a very, very different position because they need something from the company, usually money.
Yes, yeah. Although, shareholders also want money from the company, right?
That's why they hold their shares.
That's why they often hold their shares. Although, again, this is a kind of issue that is being more contested and debated, or it long has. Why do shareholders invest in companies? And different kinds of companies have different motivations. So even if you take the conventional view of the shareholder as an owner, if you look at a public company shareholder, then they're kind of obviously the narrative is that they're diversified shareholders that are looking to make a profit.
Yeah.
But if you've got a small family company, even when we teach in company law, we say, well, there are other motivations being involved in a company. Like, it can be a family company and it's your living, part of the family business. It's a complex issue, but it is one of the things that we often debate. In particular in law, how much do we protect and promote the interests of shareholders versus the protection and promotion of creditors? So you'll see this kind of infiltrating a lot of our corporations law. And you were doing insolvency recently, you said. So insolvent trading provisions is one of those. Did you cover that at all? Or no?
Actually didn't cover it at all. It was very like meat and bones of insolvency, like how do you process through an insolvency, like what is the order of distribution? And to that point, one of the ways that the courts have traditionally, and the law traditionally protected creditors is to say that any money that is owed to shareholders for their shares will only be paid after all the money has been paid to the company's creditors. So all the suppliers will be paid, all the employees will be paid, all their entitlements will be paid out before the shareholders see a dime in, well, we're in Australia, see a cent in a winding up, because the shareholders, when they purchase their shares, know that they're assuming a certain level of risk. They're making an investment. That investment may or may not come off, whereas the creditors are in a much more difficult position. They don't necessarily know what the liabilities of the company are. Yeah, right. So they do need to be protected. As I tell my students in class, if we don't protect creditors, no one's going to deal with companies. Like everyone's going to say, well, you need to pay me upfront when I deliver this thing because I don't trust that you're going to pay me next month. Yes. It creates an attitude of distrust that ultimately harms business.
It's about risk mitigation and, dealing with risk. We should note, of course, that company law hasn't always been the same. So we know that there used to be rules which would kind of protect the company relative to creditors, sort of saying that if directors made certain decisions or the company engaged in certain acts, then those weren't treated as valid if they didn't have internal kind of approval, whereas now we kind of have changed the law to kind of say that these decisions aren't invalid, so it kind of protects third parties. We have other protections of third parties as well. Corporate contracting is one where we look at how do we protect other parties. We balance this in particular when it gets to insolvency. So if you look back to our good faith, best interests of the company discussion, there are cases which talk about as the company goes into insolvency, the best interests of the company have to accommodate other parties, including shareholders, predominantly creditors. Yeah. All right. So the law has evolved gradually to kind of take into account more the interests of creditors as a counter to this kind of idea that it is just predominantly the shareholders or only the shareholders whose interests you have to look after.
Is that called stakeholder theory?
So stakeholder theory is, so creditors are one of the other stakeholders, right? And other than shareholders. So it's non-shareholder stakeholders. Yeah. And the one that the law has, I guess, most traditionally dealt with, because it's kind of the easy one, not the easy one to deal with, but the obvious one, I should say, because creditors provide money. Yeah. Right, so we need them. You're looking at two kind of, or they've been balancing monetary interests. You know, do we want to protect shareholders because we want them to invest in companies, or does the law protect creditors because we want them to engage and loan to the companies? And how do we balance these different interests? So it's been the one that has received a lot of attention, but obviously more recently we're seeing other stakeholder interests receive more attention. Yeah. The broader public, environmental interests, just society, employees, others like that. And
what does best interest really mean?
What does it really mean? You mentioned one there when you were talking about the order in insolvency where you said employee benefits. So this was, the law kind of looking at this other actor that has involvement in the corporation and needing to protect their interests, even potentially
above other creditors.
Because
they are creditors, but they're special creditors.
Special creditors, So it's a really interesting topic, and you can see why it's been so controversial and why we're going to speak about some of the cases that have tried to grapple with this issue and how that's been resolved. So this is a really good conversation so far. I wanted to touch a little bit on your thoughts on why it's important that shareholder claims are ranked behind creditor claims.
Yeah, so I think we did kind of touch on this a little bit already.
Okay, done. No, sorry. Covered.
I can relax. But just, taking us back to this idea that it's the shareholders who are taking on a voluntary assumption assumption of risk when they decide to buy shares in a company. You know, we've talked before a lot about public versus private companies. In fact, I think it's sort of like our main topic of discussion lately. But when you're buying shares in a private company as an incoming shareholder, the onus is really on you to do your due diligence to make sure that you're familiarizing yourself with the company's financial situation, et cetera. And the company will often facilitate that process because they want you to buy shares. They want you to make an investment. If you're buying shares on the public market, you know, the ASX, for example, has continuous disclosure obligations. So public companies are required to provide a lot of information to potential incoming shareholders so that they can make those decisions. Creditors, on the other hand, don't generally have the same opportunity to learn as much about the inner workings of a company and to learn as much about its financial situation, because often, you know, they might just be a small supplier, for example. They might be an employee.
I think there are different kinds of creditors, right?
If you're a massive bank that's making a $10 million loan to a company, yes, I think probably you're going to be doing your due diligence and having some idea of the company's ability to pay.
But I mean, it's an important thing to think about. Even this idea of a creditor, we often think of a bank. But as you just suggested, it could be a supplier of goods or services, right? That is a creditor, a small, a
small business, or a whole range of small businesses, all of whom, if they, for instance, weren't paid by this company, could well go out of business, which isn't ideal.
Yes,
In order to protect the functioning and the efficiency of business, the courts have traditionally protected creditors. So if a company becomes insolvent, they're the first to get paid, including the employees, as we talked about as having the status of creditors. The shareholders, on the other hand, having taken this sort of voluntary assumption of risk of saying, I'm investing, I may get paid dividends, I may be able to sell my shares at some point for more than I bought them for, but those things might not pan out. They know they should know, relevant to the case we're about to talk about, they should know the risks of what they're taking on. And if the company they've invested in goes insolvent, well, really, they don't stand to make any money, or they shouldn't stand to make any money unless every creditor of the company has first been paid.
Yes.
And so that's the way that insolvency law has generally worked in Australia and I think in the US as well.
Yeah, and I mean, we should point out, though, that there are different ways that creditors can also protect themselves outside of the formal insolvency, so they can get collateral, and a secured creditor type arrangement, so that, and then there are other things that you probably covered when you were writing this, in the voluntary administration process and all of this kind of other alternatives that people have to protect their interests, right? So all of the stuff that we're talking about here really is about how do people protect their interests ultimately, and another way that shareholders protect their interests in public companies, right, is the theory that you diversify. Right? That's one of the ideas of protection itself, like a market-based way of protecting your interests.
Don't put all your eggs in one basket.
Yes. Yeah. Similarly, the argument can be made that creditors should do the same. So, it depends, as you said, on the type of creditor that you're trying to protect.
Yeah.
And because it's all about power dynamics, right? Who has the ability to protect themselves? In some companies, you have shareholders who have kind of little option to be shareholders almost. Again, if you're looking at the private companies that we're talking about, sometimes it's just a kind of a family arrangement.
It's a family member,
so
that being said, though, if the company does become insolvent, the shareholders not being asked to contribute any of their own money to that.
That's another protection, right? It's like you only will lose what you've agreed to contribute.
And if the shares are fully paid, then you're... So yes, you might be in a risky situation. Yes, you might not have wanted those shares. You might not want to hold them now. You might be locked into the company. But worst case, you'll write off that investment, which I know is not a great...
No, well, I mean, this is an interesting way of thinking of it in terms of the reality and how lawyers look at it versus maybe how others look at it.
Absolutely.
So like a risk, determining what risk you're willing to take on, that needs to sit alongside the legal issues that you talk about, right? And so I think a lot of the stuff that you talk about really brings that to the fore. Like it kind of says, yes, we've got these legal rules, but then also some of it is just about how you structure and plan. Yeah.
And I'm very, my research and, the subjects I teach pretty much focus exclusively on the investor side of things.
Yeah, right. Yeah.
So I have a very, I wouldn't say unsympathetic view towards investors. We need investors. But most investors in a company ideally,
always
know what they're getting into, know what the risk is, and have, because of the separate legal entity doctrine, have a pretty high degree of protection for their own personal assets.
This is a bit out of nowhere, do you think that that is really true, that when people are investing, that they do have this idea? Because, I mean, that really is about behavioral kind of issues. So maybe some people think like that. Maybe others, if you hear there's a great opportunity or whatever, you're investing in, are you really thinking about?
Are you thinking about crowdsourced equity funding right now? Because that's what I think about every time people say that.
It could be that. And it just could be. It used to be more traditionally, it was, share market, someone's investing in a stock and you're like, why is everyone investing in this stock? I'll do it.
I'll do it too.
And I'll do it too, like without really looking into it. There are now other ways, crowdsourced equity funding or investing in crypto.
Yeah.
Even so, the idea then is, how much do we protect that? It's a big issue.
My view is, and has always been, I'm not saying it couldn't change in future, we have very robust disclosure laws.
Right.
We have very robust risk protection for retail investors.
Yep.
More than many other countries around the world.
This is true.
If you are going to commit your money, particularly to a private company or to a publicly traded company that's getting, the hype or whatever, you need to treat that investment like a gamble.
Yeah.
And people do gamble all the time. We don't stop them from gambling.
Do not gamble. Safely gamble. Is that the saying?
Gamble safely.
Gamble safe.
Gamble safely. Invest in shares safely.
Safely, yes.
If you're investing in private companies, we've talked about before the idea that it's incredibly risky. Listed companies, kind of different story. They've got a bit more track record, more information. If you're investing in private companies, you are gambling unless you're very, very good at what you do. Or very lucky.
But I have to say, this is an evolving area, like the amount of emphasis that we place on protection. So we were even talking about crowdsourced equity funding. And so when I was looking at that in different jurisdictions, there are different approaches as to how to protect people. Some jurisdictions have a requirement that you undergo almost like a training or knowledge kind of thing before you invest in crowdsourced equity funding. Australia hasn't got that approach. So that's, different ways of ensuring that people make the right decision.
Yeah.
If you look at our financial services sector, this has been a real big issue because the idea has been no matter what is disclosed, the people who are receiving this information don't understand it. It's really complex.
Yeah.
So now we've got different rules that kind of look at how do you structure a product and stuff like this. Even the way that we are trying to get people to make more informed decisions is changing. And that's, I think, where the big kind of developments in this area lie now. It's no longer make disclosure. So we moved from the start, which was like disclose, and it was kind of like Wild Wild West, right?
Yeah.
You disclosed information, and then
they may or may not
read it.
Yeah.
Then we kind of thought, people aren't engaging with that information, so we kind of refined the way that we disclose, and now we're evolving that even further to kind of say sometimes disclosure itself is not enough.
If they're not taking in the message.
And they do different kind of, and the financial services was one that I really thought of because this is the one in Chapter 7 of the Corporations Act where they've really kind of tried to change the way that we approach this kind of consumer protection or investor kind of disclosure and information kind of approach.
You know what it reminds me of? The way we teach. We're moving away from that pure lecture, here's the information, understand or don't, to this more very active learning.
Yes.
And it's sort of the onus is on, if the students aren't understanding, then what can we do to facilitate their understanding?
So it's a really interesting point because I was speaking to people from our library team and saying that even the role of a lawyer is different in how we engage with information and provide it. So like us as educators, yes, but us as lawyers has changed to this kind of approach where the lawyer knew everything and just said this is what's going to happen to how does the lawyer kind of relay this kind of information
to the client? How do they facilitate their understanding?
Yeah. So it's something that is dealt with in corporations as well as in other related kind of areas that we're interested in. And now we've gone completely.
We have gone so far away.
But that's okay. That's okay. We love a little bit of uninformed kind of discussion. Yeah.
Because we're here to have
fun?
All
right. That's fun. Enough fun for that question.
Enough fun for that question.
All right.